Yes.
Item number 1.
My Lordship.
Yes.
My Lord, I'm sorry to say, my Lord, it couldn't materialize, my Lord.
No settlement. Then argue the matter, finish it off.
We'll finish up. Now, my Lord, so far the first part is concerned, that's clause 54 contains a prohibition being supported by, my Lord, the judgment of, my Lord, Saeed Ahmad
Yes,
and
yes,
company.
you have
That
cited.
is over, my Lord. Then, my Lord, I was referring to, my Lord, the pleadings on the last occasion.
Yes.
And I have referred to the pleadings, my Lord, made in the, my Lord, petitions filed by in section 11 and our reply there and the orders passed by the court, my Lord, referring the dispute. Where, my Lord, I have said that only 4 disputes has been referred. And they also asked for the referring the dispute of interest, pendatellite, upon priesthood both, but that was not referred to. And we have, in our objection before section 11 application, my Lord, we have already raised our objection to that. Now, my Lord, thereafter I have shown, my Lord, to my Lord, the pleadings in the claim petition vis-a-vis in the statement of defense. My Lord, in our pleading we have stated that there is a prohibition in the contract, though we have not specifically said that clause 54 would apply. Now, my Lord, in this context, may I like to, my Lord, point out another important aspect of the matter. My Lord, they are arguing that we have waived. My Lord, your Lordship will kindly consider one of the important aspects, that this clause 54 was there. And the arbitrator jurisdiction comes with, my Lord, from the agreement itself, my Lord, the contract. Now, if your Lordship will kindly consider that since they are claiming that they are entitled to the interest, my Lord, in my humble submission, is it not their duty also to point out to the tribunal that though clause 54 is there, there is a prohibition, in spite of that, we are entitled to the interest. My Lord, they were nowhere stated, my Lord. Now they are arguing that we have waived. My Lord, my submission would be, my Lord, on the last occasion also I made my submission that, my Lord, by virtue of clause 54, in fact, they have waived that they will not claim the interest. So the question of further waiver will not arise. And in section 34 petition, my Lord, if need be, my Lord, I can take my Lord. We have taken all the points very specifically in volume 1. If your Lordship kindly take volume 1.
If the law provides,
My Lord,
after enactment of this section,
31(7).
that a party getting an award is entitled to pendatellite interest, if it is provided by statute, is it something they should argue, or it should follow the award?
No, my Lord, I'm not saying so, my Lord. Your Lordship, my Lord, you will not misconstrue me, Lord. My submission is that when prohibition is there already, my Lord, there is
Unless otherwise agreed.
Yes.
Now, unless otherwise agreed is for you to prove that there is a prohibition clause.
No, my Lord, I am to...
Now, once you argue that, then the onus shifts on them to argue waiver. Now, if you have not taken that point, unless otherwise agreed, they are entitled as of right to get interest. Nothing is to be argued. Like in a suit, once I establish my case to get a decree,
Yes, sir.
do I have to say that give me interest also? It is there in CPC section 34.
No, my Lord.
Please consider this.
My Lord, I understood, my Lord, what it is falling from my Lord's, yeah, my Lord, is true. But my Lord, my submission is that
And secondly, waiver or no waiver, the point was not argued before the learned arbitrator. All right.
I have been
Now,
told that it has been argued, my Lord. I do not know, my Lord.
if the arbitrator has granted interest, now under section 34, it may be legally right, it may be legally wrong. But is it such a patent illegality so as to vitiate the award?
My Lord,
Error of law is permitted nowadays, but patent illegality is not. something which is against public policy, etc., etc. It cannot be called a patent illegality. It may be granted, may not be granted. If he has committed an error, he has committed an error. Now, if he has done so, the court under 34 has no power to interfere with that award. Consider that. Right or wrong?
Now, well, in 34, if there is a clear prohibition, and it is not that they are not party to that, they are party to do that to clause 54, the agreement, my lord. They were aware of just that there is a prohibition. In that circumstances, my lord, it is not their duty also to point out to the tribunal. They are arguing that we have failed. It is their duty also to point out to the arbitrator, because your lordship will kindly consider that arbitrator will, my lord, passing the in view of the clause 54, if any interest is passed, my lord, in my humble submission, my lord, the arbitrator has exceeded his jurisdiction, my lord. And to that aspect, my lord, I have already shown the decisions earlier.
Yes.
And my lord, so far Susaka is concerned, Lord, I have made my submission earlier also that Susaka is based on his own facts, my lord. In Susaka, in 34, they have raised the question, but they have not pressed. They were pressing in before the Supreme Court in SLP, my lord. The Supreme Court ultimately came to conclusion that since you have not raised these questions, though you raised this question in 34, you have not pressed that matter. In the single bench, you have not raised. In the division bench, you have not raised. Thereafter, you are raising this for the first time before the Supreme Court. Supreme Court says that you cannot raise this question here. And it amounts to waiver. In our case, my lord, we have raised in 34, my lord. And specifically, rather, my lord, in reply to 34, in our petition to section 34, in reply, they have not raised this question of waiver. But they have argued. They have argued during the course of time, they have argued. Argument is there, my lord. I am not saying that they have not argued in 34. But 34, in their reply to the petition of 34, they have not raised this question of, my lord, waiver. If your lordship kindly permit me, I can just take my lord to 34 petition, my lord. Now, my lord, your lordship will kindly take volume 1. Page 33. Yes, ma'am. ठीक है. We have denied there here in para 8. Now page 38 is very important. Page 38, para 36. For that the award of P interest, my lord got it, my lord. So and so 12% from the deal of so and so is also against the contractual provision contained under clause 54 section H. General condition of contempt. Further, the rate of interest awarded by the learned tribunal at 12% in absence of any contractual provision is also in very high side. In this manner, my lord, there are other pleadings also at page 54. Specific नहीं है. Now, para 58, page 54, for that so and so and the claim amount of so and so, contract profit due to so and so and so and so, and the pre-suit interest of so and so amounting to itna is against the provision of the contract agreement and the substantive law of the land, and as such the same is liable to be set aside. Then para 72 at page 63. इसमें लिखा नहीं है. Page 63, para 72, further the award interest transfer appearance against contractual provision contained under the contract agreement and the rate of 12% is also highly excessive. So, and their reply at page 90. They have not stated anything over here. In para 16 to 18, I have referred earlier para 16 to 18 in our case. Only in page 91, last line, page 91, last but two line, it is denied that the award of the said claim is contrary to the contractual provisions. Then 36, 37, there are 36, 37 at page 93. Page 30, para 37 is important. The contents of the so and so petition reply are wrong and denied. It is denied that the learned tribunal has not decided the dispute relating to interest as per the terms of the contract or the provisions of the Interest Act. Para 37 at page 94. Then page 100. Page 100, para 58 to 60. The contents of paragraph so and so of the petition and reply are wrong and denied. It is denied that claim number 4 is against the provision of the contract or the substantive law of the land. Then page 106, para 72 to 73. The contents of paragraph 72 petition under reply are wrong and denied. It is denied that the award of interest at 12% is against any contractual provision or that the rate of 12% per annum is excessive. It is submitted that while the rate of interest claimed by the respondent was 15% and the rate of interest is contemplated, these are not relevant. So these are the pleadings, my lord, of both the parties. So far section 34 is concerned.
So what did the learned first court rule? First court? Trial court?
Trial court has given a finding. Your lordship will find it that in volume 2, my lord. I'll just refer to paragraph.
It has set aside the interest component, my lord. That's why the appeal. It has set aside the interest component, and that's the finding.
Oh, in 34, my lord.
Yes.
34.
In 34, it was set aside. So far, the interest component.
Page 251.
Page 251. 251. Page 251. I'm sorry. The entire aspect with regard to interest was discussed from para 56, page 251 onwards. My lord, I'll in that case, my lord, the decisions which I have referred, those were taken into consideration.
251.
251.
No.
Volume 1, 251, my lord. I'm sorry if I'm sorry, my lord, not volume 2, my lord. volume 1. Into Lordship got it, my lord. My lord, para 56, general, my lord. Now, in para 57, Saeed Ahmad and company, that has been discussed, my lord, I have referred to also. Thereafter, that all quotation has been made from there till next is 256, page para 58, Hyder Consulting UK Private Limited versus State of Odisha. Para in Hyder Consultation also, my lord, it says para 67 that has been referred. In the context of the 1996 the phrase unless otherwise agreed by the parties was explained in so and so. The phrase unless otherwise agreed by the parties used in various sections, namely so and so, indicates that it is open party to agree otherwise. During the arbitral proceeding, right is given to the party to decide their own procedure. So if there is an agreement between the parties with regard to the procedure to be followed by arbitrator, the arbitrator is required to follow this. Reason being, the arbitrator is appointed on the basis of the contract between the parties and is required to act as per the contract. Now, my lord, Bright Constructions, the quotation is there. Union of India was, I have already referred to this. Then next, para 60, State of Chhattisgarh versus SL Udyog has been referred. Then para 61, again Union of India versus Manraj Nahata, 2022, 2 SCC 331. Then my lord, para 62 at page 259, State of Meghalaya and Patel Engineering. My lord, on the last occasion, I have referred to this decision. Ultimately, para 262, page 63. This is important. Para 63, page 262, my lord. It is settled position of law that arbitrator is bound by the terms of contract insofar as the award of interest from the date of cause of action to the date of award is concerned. Therefore, where the parties has agreed to the interest shall be payable, the arbitrate tribunal cannot award interest between the date when the cause of action arose to the date of award. Then what were their claim and all that in para 64 it has been referred. Then my lord will kindly come to page para 65, page 263. Clause 54 was quoted. Then para 66, clause 31, section 31, 7A, that has been quoted. Then next, para 67, a bare provision of section 31(7) of the Arbitration Conciliation Act, it is clear that clause A relates to the period between the date on which the cause of action arose and the date on which the award is made. Clause B relates to the period from the date of award to the date of payment. In the Stan case, the arbitrator has awarded pre-suit interest on the individual claims 2, 3, 4 and 5. Thereafter, it has awarded penalty interest at 9% of the award amount from the date of arbitration entered with the reference till publication of award and full interest. Future interest at 9% on awarded amount from the date of publication of award till realization. Under clause 54 of the GC, there is a specific bar to the claim for interest with respect to any money as balance which may be lying with the corporation owing to any dispute, differences or that misunderstanding between the engineer in charge on one hand and the contractor on the other, and with respect to delay on the part of engineer in charge. That has been referred, my lord. Making periodical or final payment or any other aspect whatsoever while awarding the interest under the head. The learned arbitrator did not discuss clause 54 of the NGC nor gave reasoning for awarding the pre-suit and penalty interest contrary to clause 54. In view of the express bar under section 54 of the GCC read with section 31 Arbitration and Conciliation Act, the arbitrator could not have awarded the pre-suit and penalty interest on the award. The award of pre-suit and penalty interest provision is against the provisions of clause 54 of the GCC and section 31 of the Arbitration and Conciliation Act to the extent the grant of pre-suit interest is hereby set aside. Now, may I take to my lord? So, my lord, so far the pleadings are concerned, these are the pleadings. My lord, I'll take my lord to section 28, subclause 3. While deciding and making an award, the arbitral tribunal shall in all cases take into account the terms of the contract and trade usage applicable to the transactions.
This section?
Section 28, subclause 3, my lord. So,
All right, Mr. Agarwal, that's all?
that's my lord, and the decision, my lord, I have already referred.
Yes, you just give a list. Which ones? We have,
Compilation we have given, my lord. If need be, my lord, I'll just, my lord, sort out and give the paragraphs and other things.
no, which you have actually cited.
Only cited,
Sometimes
only,
in the
only
compilation-
cited.
Sometimes in the compilation there are 20 cases, but
No,
only five.
I am not. I'm sorry, my lord. I'll not give, my lord. I'll give the decision which I have already cited, my lord. And I have referred to, my lord. I'll give a list and then I'll refer to the paragraphs also, so that it will be easier for convenient for my lord.
And also file a short written notes.
We'll give all this, my lord, claim where the.
Very short, in bullet form.
So, my lord,
That's all.
in
10 minutes I need. Just
No, 10 minutes. Why
Yes,
you,
my lord.
only law, no more facts.
No facts, my lord.
Yes.
Just one thing for the convenience of the court. I've shared a document, my lord, with a single page. What I've done is because the pleadings are all over. So this just gives the pleadings claim wise. My lord, may just look at this document for a minute, and this is all I want to say. My lord, so far as Osaka is concerned, cited by 33 other judgments, it is a settled position. 34 courts have followed Osaka to say, since you have not raised this ground in arbitration, it will not be urged. I'm not going to waste my lord's time right now. I will put it in my written note, but what I'm trying to say is 33 courts have relied on Osaka and passed judgments, similar judgments. 34 courts, 37 courts, and the Honorable Supreme Court in matters. So it's a settled position that waiver done at the stage of arbitration is something that the party that does waives loses, essentially. Now, my lord, when you look at this chart, what I've done is, my lord, there were 5 claims in question. Claim 2, my lord, on top, my lord will see the top row. Claim 2, then the next column is claim 3, claim 4, claim 5, and claim 7. These are the claims that are in dispute, that are in appeal before my lords. On the left-hand side, what I've done is I've given pleading-wise the page numbers. So section 11, reply to section 11, statement of claim, statement of defense.
They have not preferred any appeal.
They have not preferred any appeal against 34 award, my lord. So this is only qua interest. So this is the paragraphs qua
So
interest.
the other part of the award, making an award in your favor, you have
we have already paid them, my lord.
all right.
We have not challenged, we have paid. In fact, we have paid.
1 crore 45 lakhs, something like that.
Whatever, my lord, whatever was due, my lord, we have paid. We have cleared the interest portion also on that. My lord, there is nothing pending so far those are concerned. My lord. Only one dispute with regard to some interest when the my lord,
Pre-suit and pendentalized interest is a dispute that has been set aside by the 34 court, and that is why we are here in appeal before that.
Yes.
Right? Now, these are the paragraphs qua the interest claim. So, my lord will see claim number 3. What I've done is claim number 3 and claim number 7. If my lord will see the last 34 petition row,
Yes.
no appeal has been preferred. Lord, what I will say is, if they have not challenged something in 34, the court could not have granted the same. Whatever they have done in arbitration, they have to at least make that averment that this is our ground for challenge. Please set aside the claim. They have not done so, so far as claim number 3 and claim number 7 is concerned. So irrespective of whether Osaka will follow or not, or anything else, my lord, settled position, they have to make a pleading at least in the appeal challenging the ground. So claim number 3 and 3 and 7.
Yes.
They have not challenged it in the appeal. If they have, they can show a para or page number where the appeal mentions claim 3 or claim 7. There isn't one. Now, my lord, coming to claim 2 specifically, and claim 4 and claim 5, the remaining 3 claims, is where I am relying on Susaka to say there is no denial by them during the arbitration qua these claims. So what they have done is, my lord, they have selectively shown you paragraphs. Okay, this is our pleading in the arbitration. This is our pleading in 34. But the pleadings in the arbitration, the pleadings in the 34 were claim-wise. There are specific averments made qua each claim in the appeal, in the arbitration. I am categorically making a submission, my lord. Claim 2, claim 4, claim 5. Not a whisper of this averment qua interest has been made by them. And that is why Susaka will... Yes, my lord.
They have challenged this in appeal.
They challenged it in appeal, but they did not claim it in the arbitration. So Susaka principles will apply or waiver.
This 2, 3 and 5 were not argued before us.
No, my lord. I apologize. There are 3 proceedings that have happened. One is the arbitration proceedings, one is the 34 proceedings before the trial court, and one is the 37 proceedings that are ongoing. In the arbitration proceedings, claim 3 and claim 7 were not challenged. So if they have not been challenged in appeal, this is not a ground for challenge, then they cannot get a relief qua that in the by the 34 court. So I'm saying, if you are not arguing a point before a court, you cannot even ask for that point, ask for that claim. So therefore, claim 3 and claim number 7 should not be granted on that ground. So far as, my lord, claim 2, claim 4 and
But
claim...
it's only interest on that claim which is before us.
Interest, just interest, the interest aspect only. I'm not arguing on anything else, my lord. The entire argument by both sides is only on interest, that too pendentalite and pre-suit interest, my lord.
Yes.
So, to reiterate, claim 3 and claim number 7, not challenged in the 34 appeal / trial court. Therefore, trial court could not have set aside my claim qua interest in claim 3 and claim 7. Now, my lord, so far as claim 2, claim 4 and claim 5 are concerned, my submission is, my lord, that claim 2, 4 and 5, the principle of waiver will apply because they did not argue these points of interest in the arbitration proceeding. Not a single word, not a whisper of contractual prohibition, not a whisper of section 54. So because they have not argued in an arbitration, the principles of Susaka, as upheld by 33 other judgments, will be followed. Apologize. And therefore, they will not be entitled to get this relief by the 34 court. They should, and 34 court has referred to the fact that we have relied on Susaka. The order records it, but they have not dealt with that aspect.
Yes.
Yes. There is one legal argument that I had taken, my lord. I will not press on it. It was just that there are points sometimes taken which are not pressed before the court. What I have tried to endeavor is show all the pleadings that were there before the court to show that they have not written it also. The one paragraph where they have shown they have actually argued contractual prohibition is not evident from the award. So there are several Supreme Court, in fact a constitutional bench judgment of the Supreme Court which says that a lawyer tends to write a lot of pleadings in his appeal or his reply or his suit. But unless you argue it before the court, you cannot burden the appellate court by saying, okay, you deal with this because this was not heard by that court. If that was the contention, they should have gone in review or sort of clarification that this argument was made, this has not been dealt with, which they have not done. So I will cite that in my written note, but that's my argument.
No, what you want to cite, you cite orally. He must hear.
Yes,
written notes, he will not be able to.
Already.
It's well known. It doesn't
Very
need
well.
the idea. You give him the reference.
Yes, madam.
ये तो दिया है इसमें।
Correct, sir. By constitutional bench. Chart.
ठीक है होगा। Well, I think
Yes.
that's
My lord,
all.
give us some time to file a written note.
How much
both
time
sides.
you require?
My lord, 1 week?
My lord, can it be 2 weeks, my lord? not.
He will also get 2 weeks. You give it in a compilation, your cases.
Absolutely, my lord. These will be given in a compilation.
Written notes with annexures.
My lord, want the copy of the judgment as well with the written note?
You append that with your written notes,
Very
it'll be
well.
better.
Very well.
You also append it with your written notes, your cases.
Case laws.
Actually cited
Yes.
Will give me note.
already.
But
Hearing,
the relevant documents you will not annex, right? Yes.
hearing concluded, just in bullet form.
Absolutely.
Hearing concluded, CAB. Advocate on record or either party is at liberty to file written submissions with the court passer attached to this court.
2nd June will submit, my lord.
All right.
2nd of June. वो आपका problem है ना?
By 2nd June 2025.
Much
Lord, I'm obliged to my lord. Giving a patient.
Thank you. Thank you for your valuable assistance, both of you.
Much obliged.
Item number 1.
Yes, please.
May it please the Lordship. Lordship, this is a intra-court appeal, my Lord, against judgment passed by learned single judge. Through that judgment, my Lord, learned single judge has dismissed my writ petition on one single ground, my Lord, for one single reason. According to learned single judge, though part of the cause of action has arisen within territorial jurisdiction, he cannot, learned single judge will not exercise jurisdiction. Very limited point, very limited ground of disposal.
Is there any delay?
No, no delay.
No scope of any interim order?
Not really, because
We will admit and
we'll admit
give directions for...
issuance of notice, my Lord.
Yes.
Obliged.
Show us the order.
Order, my Lord, will find at page 190.
You are Mr. Jindal or Mr. Kharmojai?
Mr. Jindal, my Lord.
Jindal, yes. Yes, please take down. This is an appeal from a judgment and order dated 23rd April 2025, made by a learned single judge of this court in exercise of his jurisdiction under Article 226 of the Constitution of India. Full stop. The writ petition has been dismissed on the ground that this court has no territorial jurisdiction to entertain, try and determine it. Paragraph. The writ petitioner appeals from that decision. Stop. We admit the appeal. Paragraph. Advocate on record for the appellant shall cause the usual notice of appeal to be issued and served upon the respondents. Next, we expedite hearing of the appeal by dispensing with all other formalities. Next, advocate on record for the appellant shall prepare and file in this court an informal paper book by 13 June, 3 weeks,
13 June, my lord.
by 13 June, and serve copies thereof on the respondents or their advocate on record at least 1 week before the date of hearing of the appeal. List the appeal for hearing on 25th June.
My lord, regarding the paper book, my lord,
Yes.
Every single paper available with the learned single judge is part of the memo of appeal already. So maybe
You see, the paper book, the convenience is that it has an index, page number. It's very
Understood.
easy for the appellate court.
Understood. Appreciate.
You
appreciate.
prepare that with a kind of an index, etc. That will do.
We'll do that. We'll do
That is why we have said informal paper.
info. Appreciate. Objection.
Namely, petition, opposition, reply, the judgment under appeal,
That's
petition with annexures,
That's all.
where the page numbers are there, so that the court can very easily go into it.
Objection.
Number 2.
Wait, please, Your Lordships.
Yes.
Lordship, we have taken instructions pursuant to the last order. The appointment of respondent number 5, who was appointed as interim headman, has since expired, Lordship. It has not been extended till date.
You are the appellant.
Sir, she is for the appellant.
I am the
I am for the respondent 1 to 4.
one
For the
to
private respondent, Your Lordship.
They were challenging your appointment.
No, her
My
appointment.
appointment, Your Lordship.
You are for?
I am the appointing authority, Lordship.
I'm the private respondent. They are challenging my appointment, Your Lordship.
So it has expired. So
yes, my lord. So it has become infructuous, the case of the respondent number 5, my lord. Now we are challenging the bifurcation, which I have been removed from one part of my village, Goladegli part 2, because I was appointed as a Gambura for Borshibanda and Goladegli part 2.
So what has the learned single judge held?
No, he is
Oh.
holding that as per the rules, my lord. In instruction, executive instruction, rule 162 to D, 62D, it is not been followed by the learned single judge, my lord. And moreover, the Gambura has been treated as a government servant, my lord. So Article 311(2) is applicable. That opportunity has not been given to me, my lord. And another question is that the appointment and bifurcation has been made during the court of MP election, my lord. During that relevant period of time, not the state government, nor the statutory body can appoint anyone, my lord.
So we will record that your appointment has not been extended.
No, if I may explain, Lordship, the appellant was appointed as the headman of 2 villages by
Let
us.
it be. her client's appointment has not been extended, respondent number 5.
Lordship.
And the appeal can be heard out on the other issues?
Lordship.
Yes, ma'am. Yes, I am continuing as a headman of both the villages till now.
We have been informed that the term of the respondent number 5 has come to an end on 30th November 2024. We have been informed by Mr. De.
Yes, Deb. Lordship.
Deb, appearing for respondent numbers 1 to 4. Therefore, that issue in the appeal has become dead. Now, therefore, the issue regarding appointment of the respondent number 5 as Gaon of Voladigli Part 2 village on bifurcation of Burshi Banda Goabura. You will find this in the order dated 5/5/2025. This spelling has become infructuous. No, has become dead. Paragraph. The appeal will proceed on the other issue concerning bifurcation. This is a village, Goabura.
Oh, actually, it should have been Borshibanda village. Gaubura is the what we say in Bengali also, Lordship, headman.
Okay. On the bifurcation of Burshibanda village. Next, by our order dated 7th November 2024, we had said that the appeal would be heard out on the papers in the stay petition. List this appeal for hearing on 16 June.
Okay.
Published.
Number 3.
May it please, Your Lordship.
Yes.
Lordship, in this matter, I pray for some accommodation. Your Lordship, as the learned senior counsel, Mr. D.D. Das, is undergoing treatment, Your Lordship.
Under treatment.
Yes, Your Lordship. If Your Lordship can give a longer date, Your Lordship.
What has happened to him?
A severe back injury, Your Lordship.
He is here or outside for treatment?
He's here only, Your Lordship. He's in Guwahati.
Mr. D. Das.
Yes, Your Lordship.
My lord, we have been informed about his treatment. We have no objection.
On the ground of continuing illness of learned counsel for the appellant, as informed to us by his junior, by consent of learned counsel for the parties, this appeal is adjourned till 23rd June.
My lord.
1 month.
My lord.
Much obliged, Lordship.
Single bench will sit in 5 minutes.
Told you.
Item number 1 to 5.
This is that criminal petition matter which your lordships have heard in part. Before I begin, just one issue I wanted to point out. The charge sheet filed by the CBI runs into basically 10,000 pages and more. For the purposes of this criminal petition before your lordships, we were in the process of making a small compilation of roughly about 40-45 pages which are relevant for our purposes. Because this is the only aspect that we are referring to, because against me, my lords, there is an allegation of forgery. And I would have to rely on the statement of the persons concerned on the basis of which that allegation is sought to be sustained. I was only praying if my lords kindly grant me a week's time to file that compilation before this honorable court.
No, I am asking you this because to get assistance,
My lords.
that suppose in 482,
My lords.
we find that the charges are very vague and do not point to any offence. And say, for example, assume that we say that the charge sheet is defective. Is there scope of filing a fresh charge or the whole proceeding goes?
These proceedings, my lords, to my humble understanding, my lords, these proceedings will have to go, but it depends on whether my lords would then give leave to the CBI, my lords, to further investigate in the matter and file a fresh charge.
No, because our constitution says that no person will be prosecuted twice for the same
offence. Which is why I say, my lords, then it would depend on this honorable court whether leave is granted to them.
The court can't give leave against provisions of the constitution.
My lords.
If he or they are discharged, they are discharged.
They are discharged.
There is no scope of bringing a fresh charge.
My lords.
For the same offence.
For the same offence, no, my lords.
Well, here what happened, my lord? After the charge sheet was filed, accused number 1, they filed an application for discharge, my lord, under 227 of the CRPC. That was heard by the court below, my lord, and elaborate order has been passed, my lord. Against that order, they have come before this honorable court, my lord.
You see, the thing is what Mr. Khurshid Alam was pointing out, the main thing which I have been able to understand,
My lord.
that everything was done by a committee of 5. Signature marks. Now, if there is interpolation, forgery, fabrication, etc., it should be mentioned in the charge sheet how that particular accused was involved in the commission or in the abatement or aiding of that.
My lord.
Now, in the absence of that, according to learned counsel, the whole charge falls.
For instance, my lords, if I may, in my case, my lords, one of the allegations is in respect of the Shillong Center, the list which is prepared by the committee, my lords, was not available. Then one of the members, my lords, Mr. Sun, provides a photocopy of that particular list, which he was the chairman of that particular 5-member team, my lords, which had prepared the list. Now they say that the original is not available. He takes out something from his pocket and says that this is what we had submitted. So they treat that as the original, and on the basis of that, my lords, that entire allegation of forgery is made out against me, where there is no original.
But nevertheless, there is a provision in the code for supplementary
charges
to be filed.
Yes, that is there.
That, my lords, that liberty, I don't think the CBI has taken. They say that there is a comprehensive charge sheet.
No, on the basis of the existing charge sheet, if the accused is discharged, gone.
Discharged.
No supplementary, nothing.
It's simple, my lords. If the original is not available, any document which is, my lords, supposed to be a forgery of that document, it cannot be established.
Well, once Mr. Paul...
But Mr. Deputy Solicitor General, you will assist the court on this point.
My lord.
That suppose if it is found
My lord.
that the charges are uncertain, vague, nothing to point particularly at a particular accused. No particulars of charges are there. And whether the accused is can be discharged. An order of discharge can be passed, and if it is passed, no further prosecution.
I'll try to assist on that.
Yes, Mr. Paul.
I was only praying, my lords, that your lordships permit me to make that compilation, because the entire set of documents, my lords, is not required. We were ourselves trying to wriggle out of it, my lords, more than 10,000 pages.
Supplementary affidavit.
I'll prepare a compilation, my lords. It's just extracts from the charge sheet and the relevant documents on the basis of which those allegations are made against me.
Those particular heads of charges, or
Yes. Like I pointed out, my lords, in respect of one of the allegations against me is there's forgery of the final mark sheet, score sheet of Shillong.
so those you want to cull out and make
I'll cull out, I'll make a compilation and file it with this honorable court, my lords, so it'll be easier for your lordships also to deal with the entire issue.
Yes.
I have no objection, sir.
I'll ensure that my friend has a copy in advance. So it's their documents, but I'll nonetheless have to do it.
There are 3 accused.
Yes, my lords.
You are the second.
I am A2.
Who are you by designation?
I was the then director of the Department of Education, Elementary and Mass Education.
And the third accused?
I think it was the deputy director.
Who was the third?
I was the then additional director.
Additional director.
This criminal case arises from the selection and appointment of assistant teachers in lower primary school, Government of Meghalaya, in the year 2008-2009. Full stop. The case was investigated by the Central Bureau of Investigation, (CBI). The charge against the accused is of subverting the selection process by interpolating, forging, or fabricating the examination results so as to help specific candidates. Paragraph. This particular application in the High Court, in this court, no, you strike that out. Applications under section 482 of the Criminal Procedure Code. Now, give the new act. Have been made by the three accused for quashing of the proceedings. Full stop. The prosecuting agency CBI has also made an application before this court. Complaining of the order passed by the criminal court. Paragraph. In this proceeding, Mr. Salman Khurshid has concluded arguments on behalf of the first accused, who is an honorable minister in the cabinet of the state. Paragraph. Mr. Paul Leonard, senior advocate, has started arguments on behalf of the second accused, who was director in the Department of School Education of the state at that point of time. Paragraph. Today Learned Counsel seeks leave of this court to file a compilation containing the specific charges which have been leveled against his client out of hundreds of charges which have been included in the charge sheet. In the charge framed. Full stop. By this exercise, Learned Counsel would try to demonstrate before the court that the charges are vague and uncertain and do not point or disclose any offence against his client. Next, such leave is granted. The compilation may be filed by when, Mr. Paul?
A week's time, my lords.
19th. By 4th June. List this application for further consideration on 13 June. All subsisting interim orders shall continue till disposal of this application or until further order, whichever is earlier.
Much.